and other issues. So it's something we do all the time, and we're having to adjust our practices. We've learned a lot. I have some information that's sort of hot off the presses. I was on a different webinar just half an hour before this that raised a whole bunch of other new issues that people are thinking about that I'm going to share with you today. I am also the board chair of the Raising Special Kids board. So I am available to everyone. And if you have questions that we didn't get to, I'd be happy to take those later. So what we're going to cover today is healthcare powers of attorney, living wills, mental health care powers of attorney. I'm going to talk a little bit about do not resuscitate orders, parental powers of attorney, what if you and spouse, both parents get sick, and then the status of the court and their availability. So a healthcare power of attorney and a living will, those are two different documents. The first document, the power of attorney, enables you to select an agent, somebody that you trust, who can make decisions for you when you can't make them yourselves, when you can't tell medical providers what it is that your wishes are with regard to a particular treatment or a machine. And the living will, that gives the power of attorney direction as to what your wishes would be if you could speak. And it's a way for you to put in place sort of pre-plan. So we're going to use the Attorney General, the Arizona Attorney General's life care planning packet. It is very easy to use. It's fabulous. It used to be really clunky and difficult. You had to download it and fill it out by hand, but now they have these wonderful fillable PDFs that make it really easy. They've simplified the questions, made the directions more clear. So it's really, really a nice packet. And best of all, it is free. And so you can download the entire packet, which contains all of those documents at this website here. So it starts with the life care planning checklist as a list of all the forms in the packet, so you can track which one you've completed. It has instructions. You can decide, is this the right form for you? Because some of them may not be applicable to your situation. And it has frequently asked questions and resources for you to help in filling those out. So I'm going to talk first about the healthcare power of attorney. Surprisingly for some people, it covers more than just who's going to be your nominated agent. It enables you to make considerations and decisions about all kinds of end-of-life issues like organ donation and autopsy, unless it's legally required related to a crime, and that's a different issue. But there may be other reasons why someone wants to do an autopsy and you get a say in what happens. Burial, cremation, HIPAA consents. So it really covers the whole broad array of what someone may need if they need to make decisions for you. So this is the first page of the healthcare power of attorney. You are the principal. So it says where I'm going to put in my information. That is the person who is executing the documents. And then the person who you trust to make your medical decisions is the nominated power of attorney or agent. And you can nominate an alternate agent. So if you have one person who's not available, then somebody else could step in. The most important thing is to keep that phone number updated. If something happens to you and they don't have a good phone number, then this document's not worth as much if they can't reach your agent in your time of need. This talks about what you're going to authorize the agent to do and what you're not going to authorize them to do. And it allows you to make specific religious personal preferences with regard to what you don't want. So I served as power of attorney agent for my mom. She had a long-standing chronic illness before she passed. And I sometimes acted as her power of attorney, and sometimes she spoke for herself, and she told me what to do. But the one thing she always said is she just didn't want to be on dialysis. She had had a relative who had been on dialysis, and she said, I do not want that. This is a place for you to put that very specific direction if there's something you don't want. And then also, these are not checkboxes. They require your initials. You have to initial them. So these are specific wishes about organ donation. And it's really, really detailed. So you can say, I don't want any of my organs donated. You could say, I've already worked with another institution to donate my organs, that you only want, you get the whole body, only certain organs. It's really detailed so that you can tailor it to how you feel about that issue. Going on to the next page, again, asking you Is it okay if they are for research purposes or transplant or therapeutic? And you can make all of those decisions. And then it asks you about burial and funeral disposition. So you can add in if you want to be buried in a particular state, or if you want your ashes to be spread in a certain spot or given to a specific individual, so that you can provide that direction in this document to your agent. And they have the authority to make those decisions even after you've passed. So it asks you to attach a living will. If you're going to fill out a living will, it needs to be attached. Asks you to do that here to indicate whether or not you have filled one out. Also, if you have some kind of portable medical order that's related to some other illness that you have, want to make people aware of that and make sure that is attached as well. And then if you do not resuscitate order, which we'll talk about later. The physician affidavit is optional. It indicates that you've discussed this with your physician. Of course, that's always a good idea because these are medical questions. Medical questions about what does it mean if I want this or I want that, or if I make this decision. And so you can talk with your physician and have them sign it, indicating that you've had that conversation. Here, you have to think about, do you want your agent to have access to your medical records? Because that's what a HIPAA waiver is. It will give them access to your medical records. So the benefits of that, of course, is if they need to make decisions for you, the ability to authorize one medical provider to another, or to say, to get your records and help make decisions. On the other hand, there may be things in there that you don't want shared. And so you have to think about that. So you're going to sign here at the end. Note at the top that it's completely revocable. The healthcare power of attorney, at any time you decide, I've completely changed my mind, I don't want that person involved, you can rip it up, download another one, you can do it every day if you want, completely revocable. You're the principal, so you're going to sign your name here. And you do not need a notary, which of course now with COVID-19 is very, very important because it's hard to find, and their banks aren't open offering notaries. So you don't need a notary. You do need witnesses if you're not going to have a notary. Now, if you have someone who is a notary, you certainly can use that, but you don't have to. Very important that you don't sign until you're with your witnesses, because they are to witness you signing. That is the purpose of the witness, not that you wave the document at them. So you have to sign, and it has to be in their presence. The following people cannot be witnesses. They can't be under the age of 18 because they don't have capacity. They can't be related to you or entitled to any part of your estate. They can't be appointed as your agent or involved in your healthcare. So those are the people who cannot be witnesses. You can get a friend or a neighbor, and you can do what I would call a socially distant, through the window, maybe witnessing, so long as they see you sign it. That's all they need to be able to do, is see that you sign it, and then they're going to sign the document. Lots of people are putting them in boxes, each signing their part so they don't have to touch the same paper. So there's a lot of ways to work that out so that you can get your witnesses and get the documents executed. You want to make clear to your agent that your agent can make decisions from far away, because now they're not allowing people in the hospital. When I was with my mom, I came in, I gave them my power of attorney, I wrote my name on the whiteboard with my phone number, and that's how it worked. And now you can't come in. And so you need to be sure to send the documents with the person who's going into the hospital so that they can hand the medical provider the power of attorney, or if an EMT is going in with them, or however that's working. My sister-in-law's mom just had to admit her husband, who has dementia, into a hospital. And so that's what she did. She put together a packet, and it had the healthcare power of attorney in there. And it also had some instructions on things that he would need because he's not able to speak for himself. One of those instructions that you can execute as part of this healthcare power of attorney, because you can attach addendums, is you can write in there, I want them to be able to make decisions for me electronically over the phone, just to make that clear that that is your wish. So who should have a power of attorney? Everybody over the age of 18 should have a power of attorney. And all of your adult children, your friends, your family, your neighbors, everybody can download these same documents and execute them so long as they understand the documents. We see in our office, because we do guardianships, we tragically see a couple of times a year where a young adult has had an accident and they need someone to make medical decisions with them. Let's say they suffered from a traumatic brain injury and they don't have documents in place. And so we're in the position of helping that family get an emergency guardianship. The court is still hearing those types of emergencies, even when they have been largely closed this last month. But you don't want to be there. That's the last thing you need when that kind of tragedy has happened. So all of your kids, I have 5 kids, every single one of them has these documents. They turned 18. I said, here you go. You need to fill it out. And they have. And so I would encourage you to share the wealth on this. This is something you definitely want to share with others, that it's free and right now really, really important. So Neil, I am prepared to take questions on healthcare powers of attorney.
All right, we've got just a couple so far. The first one is from Jenny, and it was, do we not need a notary only during COVID-19?
That's a great question. And the answer is no. Arizona has always been pretty liberal, and it's always been acceptable to have 2 witnesses. So it's not related to COVID-19.
Great. And then the other question was from Robin, and it was, what do we do with these forms for healthcare power of attorney after we fill them out? Do we just give them to the person who's nominated?
So yes, we're going to have a whole discussion about that. But yes, you want definitely to the person who's nominated, certainly to your medical providers. It's good to have extra ones laying around too. Can't hurt at all. To have those around, they need to be easily accessible, and I'll go over all of that as well.
I've got 2 more that just popped up. One from Lori that is, if you have a spouse, do they automatically serve as power of attorney?
That's a great question. So yes and no. The answer is, can they make medical decisions for you under the surrogacy statute? The answer is yes. A spouse stands in priority, and there are other people who are priorities after them. It's a list in the statute. So it could be a parent, it could be a sibling, it sort of goes down the line, but the spouse is certainly the number 1 in priority. But they're not the power of attorney agent. So that statute, the medical surrogacy statute, it has limits. So if someone needs something more than immediate acute care, I mentioned the person who maybe suffered a traumatic brain injury, and so that's not going to recover often very quickly. And there's going to be a whole series of medical decisions to be made. Once the sort of immediate emergency is passed, the hospitals will generally require someone to be the agent or to be the guardian. And so the spouse at that point, if there wasn't something in place, would need to go get a guardianship if there wasn't a power of attorney.
All right. And one more that is generally, if the person who is going to have the power of attorney is in a different state, does that require different forms?
No, because you want the power of attorney. That's another great question. You guys are good. You want the power of attorney to be where it's going to be executed. It's going to follow the laws of that state. Now, there is some crossover. So if you were to go to another state and get injured and you had a power of attorney, it would probably still be honored. But it's not tied to where the agent is. It's tied to where the principal, that is the person who nominated the agent, the person who the power of attorney is about, it's tied to their law. So if you moved here from another state, I would redo the powers of attorney because you want them to be as closely tied to the laws of your state that you're living in as possible. But you could definitely have someone out of state who can be the power of attorney. And again, Arizona has really flexible laws. I think a long time ago, our legislators realized that we have a lot of people who have moved here for retirement, and so they have family in other places. So some states have requirements that the agent needs to live in the state or the guardian needs to live in the state, and Arizona doesn't have that.
All right, and that's all the questions we have for right now.
Great. Moving on to the living will. So this is a different type of document. You saw that you could have a power of attorney agent and not necessarily execute a living will. You've just left it to the power of attorney to make decisions as best they can, maybe without direction or guidance from you. The living will is your place to give them direction and guidance as to what you would say if you were able to say it. So it gives them, and it's about medical treatment, because most of the things that are not medical related were in the actual power of attorney. So organ donation, autopsy, burial, HIPAA consent. Now, if you have a living will, you wouldn't, it is persuasive, but you need an agent to execute it. So you're going to attach it to your healthcare power of attorney. And there was a box that said, I either don't have a living will or I have attached it to my healthcare power of attorney. So again, starting out with, you are the principal. And then it asks you a series of questions. And I think the feedback I've gotten, and I do an event once a year, I don't know if we'll do it this year, called Night of the Living Will, where we recruit lawyers and we dress up as various costume storybook characters and things like that. And we help people execute their wills the weekend of Halloween, the living wills and the healthcare powers of attorney. I find when we use the Attorney General forms, I find when we do this, that this is the form that confuses people the most, because you have the option to here, you can use any combination of 1, 2, 3, and 4. But if you pick 5, which is on the next slide, then you can't use 1, 2, 3, and 4. So number 1, it talks about having a terminal condition and you don't want your life prolonged and you don't want other life-sustaining treatment beyond comfort care. Comfort care is really the basics of just making sure that you're not in a lot of pain. And so, and they give a little definition here. So that may mean that there might not be other interventions, say if you got an infection, right? So there might not be other interventions. And it's limited, number 1 is, to a terminal condition. So maybe if you know your condition is terminal, you really don't want anything else. So that's one decision, which is why you can do it in combination. The second one is if you have a terminal condition or an irreversible coma or in a persistent vegetative state that the doctors reasonably feel is irreversible or incurable, then you do not want, you do want the necessary medical care that would keep you comfortable, so a little bit more care than number 1, but you don't want the following. And so it provides kind of a menu of what you do and don't want in that situation, which again is broader because it covers the irreversible coma and the persistent vegetative state. And so those things are resuscitation, the use of artificial breathing, we're going to talk about ventilators, artificially administer food and fluids, and some people, again, once we get to the DNRs, they don't want to be taken to the hospital. Maybe they're on hospice and they're hoping to die at home. So you could choose 1 and 2 and understand the distinction between them. So 3 is an exception to 1 and 2, and it has to do with if someone is pregnant, if maybe they don't know, but if it turns out that a woman is pregnant, she may want life-sustaining treatment to take care of the baby. So they call embryo and fetus, but if you want that, that's because you're hoping to bring the baby to term. And so that's something that women need to think about. Regardless of other decisions, number 4 is this one's talking about until they're really sure that my condition is irreversible and incurable, I want them to do everything. I want my agent to think about that. I'm 45 years old or whatever. I'm not, but I'm 45 years old and I want everything done that you can do until you're sure that that is my situation. And then 5, which is why you can have combinations of 1, 2, 3, and 4. And 5 is you want everything done to the greatest extent possible, which means 1 through 4 don't apply. Now, I mentioned earlier that you can attach special instructions, and in this time with COVID-19, because of the unique challenges that it poses for healthcare, this is really important. And so it says you can attach additional instructions. So here's some things to consider. So most people have strong feelings about whether or not they want to be intubated or on a ventilator. And so they will say, as we saw in the living will, I do not want that. COVID-19 poses an interesting challenge because a ventilator in COVID-19 is being used for a short-term illness and not for a long-term problem, which is how we have typically thought about ventilator use. And there's also been a lot of talk about, what if there aren't enough ventilators and how are doctors going to make a choice? So if related to COVID-19, I would attach something that says, if my illness is related to COVID-19, I do want the use of a ventilator, so that direction is clear for your agent and for the medical providers. Some other considerations with related to COVID-19, there's a lot of experimental treatments. And so if you've selected more limited options, then the medical providers may think, well, that's not authorized in the power of attorney because those options appear to be limited. Like, I don't want that much. But when you have a novel virus that we don't know how to treat, maybe you do. Maybe it's changed your feeling about that. Again, would be something that I would attach to that additional attachment to say, for COVID-19, I feel differently about these things. Also helpful, because they're not allowing us to come into the hospital, to create a list of who you want to see when you're in the hospital. Who are the allowed people in? It used to be people could come in and out, and when someone would have a more lucid moment, they could say, yes, that's my daughter, my son. And now that's not possible. So think about including a list of who it is that you want to be able to have phone contact with and video if you're in the hospital. So medical personnel has access to that list, even if your agent can't be there. So ready for questions on any of that, living wills and considerations for COVID-19?
All right, I've got one question. It is a living will good for letting your children know who will get what after you die?
No, it doesn't do any of that. I know lots of people have talked about having a different word for it because it says will, and it's not a will. It has nothing to do with your property. It has nothing to do with who the beneficiaries are of your estate. So just to go back here, it's these 2 pages. And as you can see, it's just related to medical decision making. There's not a place in here to talk about or deal with property in every way. So that would be a last will and testament that you would have to fill out in order to take care of those issues.
All right. And if a person has a living will and they say do not prolong my life, if that person is unconscious, can an agent with a power of attorney healthcare disregard their wishes and have all medical services provided, such as breathing tubes, feeding tubes, etc., to try to prolong the person's life?
No, they shouldn't be. They shouldn't be able to do that, because in order for the agent to act as the agent, they have to have given the documents to the medical providers, which is why the healthcare power of attorney has a place there that says, I have a living will. That means that the medical provider is going to ask for that, and they would need to follow that direction. So the agent has to carry out what the person's wishes were when they had the capacity to make those decisions. So most hospitals have an ethics committee when there's those kinds of disputes, and that would go up to the ethics committee. Sometimes that very issue, there's a statute that allows for that to be challenged. So if one family member thought the healthcare agent was disregarding, or even if the hospital thought the healthcare agent was disregarding, they could seek court direction on that conflict.
Great. Any more questions? Those are the only 2 I have in the chat right now.
Okay. And if somebody thinks of something later, we can definitely revisit any of these issues.
I think I've got one coming in. Okay. And it is, do you recommend that everyone gets a living will?
Yes, I do. But that is also a personal and a cultural decision. right? So some people and some cultures don't want to talk about this, and they don't want to think about it. They think, people may feel like that just brings that into my life, and maybe I'm putting it out there in the world and making it happen. There are religious preferences around whether or not people want to have this discussion. So if that discussion is something that's not in what that culture, or this family culture of any kind, if that's not something that's going to happen, then do the healthcare power of attorney that allows for an agent to make a decision, and they're just going to make it without that other guidance. And so that's an equally valid choice if that is someone's perspective. But yes, my perspective, which is, I think I of course, I always want to have a say. So I would want to give direction to my agent. And if I'm the agent, my mother, going back to my mom, had a living will, and it gave me a lot of peace of mind in the end when she was on hospice and we had to make some decisions. And I felt much better knowing that that was what she wanted.
All right, thank you. Thanks for the questions, everyone. Keep those coming.
Yeah, they're good questions. So, mental health care powers of attorney. This document is a lot like the healthcare power of attorney. You're nominating an agent. You designate that person to make decisions when whatever crisis is happening and the person is unable to. It has the same signature requirements, the same HIPAA release. So I'm not going to go through each and every page. I'm going to show you the page that's different. So we'll go here. So again, presumably right now we're all making our own mental health decisions, but there may be a point in the future where someone is not able to, whether that's medication related or stress or another crisis. And obviously, probably everybody's under a lot of stress right now. So if they're not able to make decisions for themselves, then this document would allow the agent to make a decision. Now, it's also a revocable document. The person can change their mind. There are some exceptions now in statute that if the person is in a crisis and in that crisis is incapacitated and unable to make decisions, for example, maybe they're in an inpatient psychiatric unit, then maybe it's not revocable, but that would be up to the doctors to meet and decide on. So you can see here that, again, authorizing the agent to make mental health decisions and whether or not they're going to get records, to consent to medications, to admit to an inpatient or partial psychiatric hospitalization program. And then there may be other specific things that someone knows they need for their treatment and wants to put in there. And so that's the other. Maybe there's some program or something that they're doing that they want to make sure someone can carry on if they're not able to decide. Again, down here, you can say, there are things I do not want this person to do. When we do these documents with folks, often my example is it's related to specific medications. They'll say, I absolutely do not want that medication administered, and they want to make sure that the agent can't do that. And so that's something they may put in there. There may be particular treatments, maybe a particular hospital. So that's the place where someone could make those designations to say, I do not want that. Now in this packet, keep in mind, maybe this document's not for you. Maybe this is not something that you feel is helpful or need to execute. It's a packet that has all of the life care planning decision documents that are available, but you don't have to fill all of them out. So if this one is not something that you feel is needed, then just skip it. Are there questions on the mental health care power of attorney?
I don't see any just yet, but maybe we'll hold on for just a second to see if somebody's typing one in.
Okay.
And the only reason I want to pause there is because we get lots of questions about that when we do our turning 18 trainings. So I'm like, come on, surely somebody has one.
Well, is there anything you can think of that I missed?
No, not really.
Okay.
Let's see. We've got who is needed for secure inpatient decisions.
So I take that to mean like an involuntary or an inpatient psychiatric hospitalization. Is that, I think that's what secure means. So so this power of attorney may prevent someone from being involuntarily committed through the court ordered treatment process, or that the process where they're going through the crisis and you have to do 2 affidavits. So it may prevent that because a healthcare agent could step in and make decisions before then. So the healthcare agent could make that decision about going into a secure setting, and that may avoid the need for some of those crisis interventions, and maybe one can hope court order treatment. But if someone's really not compliant with their treatment, that's obviously a very, very challenging situation.
All right. We've got a question. As long as a person is mentally oriented to person, place, and things, can this be implemented?
That's again, good questions. So I would say that's interesting. I mentioned earlier that I had just been on another webinar, and there was a discussion about this very idea. So the concept is that some powers of attorney will say that they spring into effect when the person becomes incapacitated, which means you have to get 1 doctor, sometimes 2 doctors, to certify that the person's incapacitated. That is not going to be possible. I just went through this with a client who needed to serve as agent for someone who had had strokes, and we needed to admit the person to a facility, acute rehab, and we couldn't, because of COVID-19, we couldn't get 2 doctors to spring that into existence. These documents on the Attorney General's website don't have that limitation, which I think now is good. But if you are a person who has capacity, as we're all sitting here right now, and the agent comes in and says, I want to admit them to a psychiatric facility, they can't do that, because you can still talk and advocate for yourself. So to go back to my mom's example, my mom had a serious chronic illness. She was in and out of the hospital, and sometimes she was really lucid and great, and sometimes she wasn't. So when she wasn't, they would talk to me, and when she was, they didn't talk to me anymore, they being the medical providers. So these documents don't create a space in which you've lost control over your own healthcare decision making. They create an option if you can't exercise that control anymore.
All right. And I have one that is, what is the process if it's not a compliant person?
Yeah, so that's typically the court-ordered evaluation, or not court-ordered evaluation, but involuntary evaluation, and then court-ordered treatment process. And I used to do more of that as a lawyer, but I don't as much anymore. But essentially, it involves having affidavits from 2 people that the person is a danger to self or their others, and then getting them in for evaluation at one of the urgent psychiatric centers. And then if they are in need of treatment and they won't agree to treatment, in other words, to go involuntarily, then that's that court-ordered treatment process where there may be hearings, they get a lawyer, and the court may decide that they have to be forced to have treatment.
Great. And then I've got one, is a Title 36 authority only needed if a person does not have a mental health POA?
So in reference to Title 36, I think that's that court-ordered treatment process, because that's what's in Title 36. Guardianships are in Title 39. And just to back up, titles meaning that in our statutes, it's sort of like a book. And so criminal code is Title 13, and the probate code is Title 14. So that's what the titles are referring to. And Title 36 is healthcare, just so we're all clear, we're talking about the same thing. If a person had a mental health power of attorney and the agent was able to use it, they may avoid those Title 36 hearings. You may still end up there if the person is really non-compliant.
All right. I think that is it for now, other than one comment that this is absolutely amazing. I can't say thank you enough.
Oh, that's so nice. Thank you. It's my first webinar. So I've never done this before, and I'll just say it's really weird, but now you're asking questions, and so now it's kind of fun. So thank you. All right, pre-hospital medical directives. We know them. I think most people know them as do not resuscitate, right? DNRs. I put a big stop sign here, particularly with COVID-19. So I wanted to put out, I know it's a lot of words on the slide, but I want to make sure you had the Attorney General's answer to this question, which is, should I complete a DNR form? And the bottom line is, if you're a healthy and strong person, this is not something that you're probably going to want. It's in the packet because maybe you're doing the packet with someone who has a terminal condition and they have decided and selected that number one in the healthcare power of attorney that, no, I know what my condition is and I don't want anything more than what the treatment is for the condition. I know I'm passing and I'm okay. So this is for that person. This is not, as it says here, if you're young and healthy and strong, this is not something that you want. And particularly, I have concerns about this document because of COVID-19, it's a short-term illness. It's very serious and it might require a ventilator, but that is because we think they're going to get better. So this would prevent that potentially from happening. But if you are working with someone who this is an appropriate document, then it's a big orange paper form. That's to make it very clear that this is a big deal, because once resuscitation is started or once your various interventions have begun, then we've already invaded and done things to that person that they did not want. So this is a really important document. Also, if someone really doesn't want to go to the hospital, if they've checked that box that they want to avoid that, then it's important to have this absolutely visibly displayed so that when the first responders come in, they realize maybe there's something else for comfort that needs to be done, fluids or something like that, but they're not going to resuscitate the person if they go into cardiac arrest. So if they are going to use this document, it's an orange piece of paper, keep it posted visibly, and very importantly, talk to your doctor about that. This one you got to talk to the doctor. So I'm ready for questions.
I've got one right now from Jenny. It says, do you think COVID-19 will change the way these forms are written? Will there be more options going forward?
So the webinar that I was on earlier, it was a bunch of estate planners, and that was a huge discussion. And there are people right now drafting addendums for folks to have to their healthcare powers of attorney and their living wills, specifically to address this. If I come across one, I'll definitely be sharing it with Raising Special Kids so they can share it with the families that they work with. So I do. I think the answer to that is yes, I do, because it's definitely changed the way I think about a ventilator. I did an addendum because I didn't really think about it that way. And the other thing that it changes is all of a sudden we have a situation in which the person who you think, oh, it doesn't really matter because my husband knows what I want. Yeah, you might both be sick. You might both be unable, and we're gonna talk about that next, to express those wishes. So it's now more important than ever to have it in writing.
Great. I have another question is, can a parent revoke a DNR at the time of crisis for their medically fragile child? What if they change their mind and ask for medical intervention?
So that's an interesting question. So that, I think the way it's asked assumes that it was the parent who maybe two things. One, I don't know if this person's a minor or an adult, so I'll address both. If the person is a minor, then the parent can always make that decision. And so they don't need a DNR because they always have that decision making. If we're referring to an adult who maybe is under guardianship, the guardianship statutes say the guardian has the authority to make that decision. And because the authority lies with the guardian, then let's say the guardian executed a DNR and then changed their mind. Well, that's a revocable document on behalf of the guardian.
Great, thank you. Let's see. I don't see any more questions right now.
All right, moving on. So you can register your documents with the Secretary of State. Those forms are also in the packet. So you can, and here's the website where you can make that registration. And so getting to that other question, you filled out all the forms, now what? Well, you got to have the documents witnessed. Without witnesses, they're not valid. You need to keep the originals in a safe place. It's easily accessible. Give copies to your healthcare agent and your doctors. I would keep a few extra copies. So that's all the steps you're going to take. Register them, have them witnessed, keep them. Don't put them in your safe deposit box, because whatever is going to happen is most definitely going to happen at 6:30 when the bank is closed. In your wallet, there's a cutout card that you can carry with you so that you can so let's say you're out, you're driving, you get into a car accident, you're not carrying around your power of attorney, but in your wallet, they'll be able to see, oh, this person has directives and who to contact. Any questions about registration or anything in general, really?
None just yet. Oh, I've got one from Lindsay that is, what about the 5 Wishes booklet?
So that is a valid document in the state of Arizona and can serve the same function as these documents. So 5 Wishes is more detailed. I like that document. I think it's really nice. The thing I like about the Attorney General is that it comes from the Attorney General. So it's been widely accepted for a very, very long time. And I think the likelihood of getting pushback on whether or not that's a valid document because it's so widely used is probably maybe less. But the 5 Wishes, as my understanding, is recognized in Arizona, and it is very nice. And it's more detailed, and it walks through all those choices in a really nice way.
Great. Let's see. Is there a way to have the wallet card be on a phone instead of being a physical card?
I don't see why you couldn't take a picture of it. Yeah, I mean, I assume you could, just like anything else, fill it out and take a picture and put it someplace where people can find it, wherever you keep your emergency contact information.
Okay. And then I have one, let's see. It says, we are guardians of an adult with a disability. We have the authority to make medical decisions, but should we still be writing our wishes down on his behalf in case we become ill and can't make those wishes known?
All right. And so what I should have said, and Neil, we forgot to say it, is that I can't give any specific legal advice. This isn't legal advice. It's just general information. But generally speaking, it seems to me that COVID-19 has highlighted, right, that real potential for an issue. I mean, we've seen families where whole families have come down with it, and what's going to happen if both guardians aren't able to express what they would like. So I think, yes, in this time, that would be really helpful, and designating who's going to make those decisions also would be important. There's not, in the guardianship statute, not a really good way to do that. I'm going to talk about parental powers of attorney, and there is a special power of attorney that I thought about discussing but decided not to because I don't know that it really applies to guardianship. But definitely making those wishes known and saying, this is who I want to make these decisions and what decisions to make would be important.
Great. And the last one I have here is, does the 5 wishes need to be notarized?
Hey, you've gotten to something I don't know the answer to. I don't know. I don't know the answer to that. My feeling on it is, if the one that is sanctioned by the in law in Arizona requires 2 witnesses. I don't see why 5 wishes wouldn't as well. Because it's not codified in statute. So it seems like it should just be able to take 2 witnesses, but I haven't looked at the form. I haven't downloaded the form in a long time to see what actually it has at the signature blocks at the bottom.
Okay. I think there's a kind of an add-on that says not notarized in Arizona, but some states you do for 5 wishes.
Yeah, that some states very specifically require all of these documents to be notarized. I was just on a call with someone in Alaska, and that's been a huge problem for them because it requires a notary. But in Arizona, it's 2 witnesses, so we're fortunate.
All right, and then one more. Does the POA-HC need to be activated by 2 doctors before the agent can make decisions for that person?
No, it doesn't. And that's what I was talking about, that springing power. And there are lots of healthcare powers of attorney like that in existence where you do need the 2 doctors. And I was just saying, I had that experience where we could not get that because of COVID-19 and all the restrictions on who could go into a facility. So they don't, though. These documents don't have that springing clause in them. So it's going to be an assessment by that medical provider as to whether or not the person doesn't have capacity and the agent needs to make the decision.
Great, thank you.
All right, parental powers of attorney. So something else we now have to think about, this going back to what happens if both parents get sick, or maybe there is only one active parent. So the Maricopa County Superior Court has parental powers of attorney. You can download them here. So step 1, download. Step 2, this does have to be notarized. And that's unfortunate. So you are going to have to get a notary. I have been working with some mobile notaries who are doing, I would call it like driveway notarizations, where you put it in the box, everybody signs, you're standing far apart. So some people are still doing that. There's still, and in our office for estate planning, we're doing some drive-up notarizations. So, but this one does have to be notarized. And then here are the steps and how the copies that you should make, keeping the originals. The form looks like this. It's a very, very short form. As the parent, you have the authority to delegate because you have all of the rights in terms of decision making. And so you delegate which child it's over, what's the scope of the authority. The interesting thing about parental powers of attorney is that it can't be valid for more than 6 months. So that's this piece here. They have to be renewed every 6 months. Now, related to COVID-19, that's probably not so relevant. But if you had a longer term need for a parental power of attorney, it would have to be renewed every 6 months. And questions on that?
All right, we've got, can you use the parental powers of attorney in every county in the state, or can you only access them on the Maricopa site?
So that's a great, yeah. Most of the counties have the really good online forms. The Superior Court's been really, really active in making that happen. There might be some counties that don't have them, but the form is in statute. So it seems to me that the worst case scenario is you download it, white out Maricopa County, and write in what county you're in might be an option.
All right, and are parental powers of attorney valid for adult children under guardianship?
That is the quandary. I did not see that would be an option. And because guardianship is a court delegation of rights, I don't know if the special power of attorney will work. The guardianship statute does say that you have the rights like a parent to a child. So I decided that that's something I need to do some more looking into.
All right, any other questions? All right.
Okay, so we're talking a little bit about what the court is doing. So the Superior Court, particularly in Maricopa County, So that's why I put them here, calling them out. No, they've done a great job, but they basically canceled all of the hearings in the month of May when the stay-at-home, I guess not technically in order, but when we were encouraged to stay at home, they canceled all the hearings. It takes a lot of people to run a courtroom. There's a judicial assistant, there's a clerk, there's the judge and the commissioner, there's someone who's running the recording device. So there's just a lot. It's a crowd. It's a crowd all the time. So they canceled the hearings, and now they've had to redo. And I just want to show you. So I wanted to show you the activity here. So they've got a whole page, and and they're trying to pivot. They're working really, really hard at that. All of these administrative orders, where now they're changing what they're doing. It used to be, particularly in Maricopa County, that there were not video conferencing hearings. There were not very many telephonic hearings. If anyone wanted to appear by phone, they had to file a motion and say, I have a good reason why I should be able to appear by phone. And so now they've had to flip everything backwards and figure out how to have conference lines. The lawyers used to be the ones who set up the conference lines. And so now the court has conference lines, and they're working on GoToMeeting. So they're learning to pivot just like everybody else. These are all of their admin orders. You can see this is the amount of work that the court is doing. It's coming out almost every couple of days as they try to provide guidance in every county and to every person, and make changes to what needs to be notarized, lift requirements for what documents need to be original. So they've been working really, really hard. It looks like, they are open, and it looks like they're gonna do a phased return as well. It looks different in each county. And again, the opening will look different in each county because it's gonna be related to how many cases they have, what they're on the up or the down. It is looking like often, to at least the near future, there is going to be more limited jury pools in Maricopa County, and that's where I practice. It was 100 people who were coming in, and some of you've been, I'm talking about. It's 100 people in a little room all day long, waiting to be called, sometimes called for jury, sent back. So they are limiting the jury pools. They are in creating space for social distancing measures so that they can start to reopen the courts safely. Like I said, real liberal telephonic hearings, starting some video conferencing hearings. I did my first video hearing a week ago, and it went great. So it's all going to work out. They are accepting new cases. They have prioritized emergencies. So if someone needs an emergency guardianship or other urgent matters that can't wait, they have had staff there making that happen. They've loosened the notary requirements. It used to be that we would get hearings, and 9 o'clock there were 5 hearings scheduled for the 9 to 10 hour. So it looks like they're going to maybe start staggering those hearings so that there's less people there all at one time. And there's just constant rule changes. And if you are, say, filing for your child who's turning 18, you can still do that. They're still taking those cases. They're going to be setting them. They are, maybe by video, they are allowing court investigators to FaceTime, and the same with court-appointed counsel to meet with people. They've, some socially distant meetings also. Each judge's division is still run by that judge or that commissioner. And so it's important, there's that main guidance on that website. Also important to understand what the individual judge is going to be asking of the people in their courtroom. Any questions on that? That's going to be my last topic too.
All right. Well, I don't have any in the hopper right now, but we'll see if some come in.
Yeah, it was so interesting to me that our courts, they had the technology, but they just so they really had to sort of change their mindset. But they've done a good job.
I've got one question. Can we get the PowerPoints or links emailed?
That is going to be a question for you, Neil.
Yes. Yeah, we'll send out an email within probably a business day or so, either with the PowerPoint itself or the links that were inside of it. Let's see. I've got one that is not related to the last topic, but do you know if Arizona hospitals will allow a legal guardian to stay with a COVID-19 patient who is an adult with a disability?
So I think that is changing. The answer is no. But what I'm hearing from my clients is no. That's what I've heard thus far. But I think it varies by hospital because those are private entities, and it might vary based upon what their incidence is. I know my poor sister. So her husband had to go into the hospital, and they told her that anyone with any kind of contagious disease was in a different building, and he was having an allergic reaction, anaphylactic shock. And so he was in another building, and he didn't even spend any time in the ER. He literally walked in and they took him back to a room by himself. And that was important for her to know because my niece who has Down syndrome, she has leukemia. And so she's in the hospital for rounds of leukemia for about a month at a time. And they had just come out when he went in. So it's sounding to me like it's really restrictive. My clients who even for my niece, they only allow one parent in to stay with the child at a time now. So for my clients, what I'm hearing is even if the person's nonverbal, they're not letting people in. But it might vary by hospital.
All right. Well, I've got that is a great question and a great presentation with important information. Thank you.
You're welcome. Thank you all for having me. Thanks for listening, and stay safe and stay healthy out there.
So really quickly, I'm going to post a link to an evaluation in the chat just so we can get some feedback and make sure that this was useful and helpful for everyone. So if you could just take a few minutes to fill that out, we would really appreciate it. And I'll include the link in the email I'm going to send out later as well.
I would really appreciate it too, because I've never done a webinar before. So help me. What can I do better?
There's the link. Thank you so much, Jennifer. Really, it was a great job and so much good information. A couple of the folks in the chat were staff members, and they were expressing how much they really appreciated the additional information and that it'll help them serve parents better. So we really appreciate it.
Good. All right. Thank you.
All right. Thanks, everybody.
Bye.